Introduction. Marketing and advertising has long been the subject of scrutiny from the public, special interest groups, and the government. This chapter examines legal regulations and ethical concerns that have been raised about marketing. In this unit we will discuss material about the legal environment governing marketing followed by industry oversight. Ethics and advertising and ethics and marketing are discussed as well as how marketers are responding to ethical challenges. Regulations. Here is a perfect example to be diligent in following regulations. Reebok's Easy Tone and Run Tone shoes are popular with 10 million pairs sold worldwide and 5 million in the United States. Reebok made claims that the shoes would tone a person's hamstrings, calves, and butt. FTC investigated the claims and fined Reebok $25 million. According to the FTC, Reebok's claims were not sufficiently supported. Reebok complied with the FTC ruling, but disagreed with the decision. Reebok believed the claims were sufficiently supported. Skechers agreed to pay $41 million after the FTC felt similar claims were not supported. The Food and Drug Administration, FDA, regulates and oversees the packaging and labeling of products. It also oversees advertising on food packages and the advertising of drugs. The Federal Communications Commission, FCC, regulates the television, radio, and telephone industries and grants operating licenses for radio and television stations. The FCC does not have jurisdiction over the content of advertising, but does oversee the amount of advertising directed towards children. Currently, TV stations are limited to 12 minutes per hour during weekdays and 10 minutes per hour on weekends. The U.S. Postal Service, USPS, has jurisdiction over all mailed marketing materials and investigates cases of mail fraud. The Bureau of Alcohol, Tobacco, and Firearms, ATF, oversees the sale, distribution, and advertising of alcohol, tobacco, and firearms. The Federal Trade Commission, FTC, is the primary agency that oversees marketing and advertising. The FTC was created in 1914 by the passage of the Federal Trade Commission Act. It oversees all marketing communications materials. The original intent of the FTC was to enforce antitrust laws. Then in 1938 the Wheeler-Lee Amendment was passed expanding the power of the FTC to stop unfair and deceptive advertising practices and to levy fines. The FTC was also granted access to the courts to enforce the agency's decisions. The 1938 Wheeler-Lee Amendment gave the FTC three powers: 1. To investigate cases of unfair and deceptive advertising, 2. To stop unfair and deceptive marketing practices, and 3. To levy fines. An advertisement is deemed to be deceptive or misleading when it meets these two tests. A substantial number of people or a typical person is left with a false impression or misrepresentation of the product, and that false impression induces people or the typical person to make a purchase. Companies can be charged with unfair and deceptive advertising even if they did not intend to mislead. In other words, intent is not a factor in the decision. It is important to understand the difference between puffery and deception. Puffery is an exaggerated claim about your product and is not intended to be a factual statement. The FTC understands companies brag about the greatness of their products and have the right to do so. A claim is a factual statement about a product and must be substantiated. Puffery includes the words best, greatest, and finest. These are okay. In the past, the word better was considered puffery. The word has recently come under court and FTC investigations because it implies a comparison and that one brand performs better than another. As such, the FTC says you have to be able to prove that it does, which then makes better a claim rather than puffery. Claims or promises in advertising must be substantiated. If an endorser is used, then the endorser must be truthful. It must represent his, her personal experience and personal opinion. Any expert endorsement that is used must be based on legitimate tests that would be accepted by anyone in that industry. When looking at the substantiation of claims, the FTC utilizes 4 principles to decide if an ad has been adequately substantiated. First, the FTC assumes consumers read ads broadly and do not pay much attention to small print and qualifying language. So, Hiding a disclaimer or qualifying statement in small print is not acceptable. Second, the evidence must be for the actual product, and if a comparison is used, for the actual comparison product. It cannot be for a product that is similar. Third, any evidence from experts must be from individuals that are considered experts in their chosen industry. Fourth, the FTC and courts will consider all of the evidence available. If a company has one study that shows it is superior in some way, but 4 other studies show it is not, the FTC would accept the other studies as greater evidence. Complaints for unfair and deceptive marketing or advertising can be lodged by anyone, consumers, businesses, Congress, or the media. Businesses are a major source of filings with the FTC because they want to protect their brand, so statements made by competitors, even if they are not comparative ads, will often be challenged. When the FTC feels an ad is deceptive or misleading, it will first issue a consent order. With a consent order, the company agrees to stop the ad or marketing practice, but does not admit guilt. Most companies follow a consent order issued by the FTC. But, if the company feels the consent order is wrong and wants to appeal the decision, or the company does not abide by the consent order and continues the marketing practice, the next step is an administrative complaint. The administrative complaint is before an administrative judge and is handled just like a court proceeding. Both sides can present evidence and argue their case. If the FTC feels the marketing practice is unfair or deceptive after the administrative hearing, then it will issue a cease and desist order, which means the company must stop. It no longer matters if they agree or not. If the company appeals the case, the next level would be before the full FTC Commission. From there it would go the U.S. Court of Appeals and then to the U.S. Supreme Court. Most cases stop with a consent order, a few will go to the cease and desist order, very few ever get appealed any further. The first step in the process is an investigation by the FTC. If the FTC feels a violation has occurred, it will result with either a consent order or FTC settlement. If the company does not agree or wishes to appeal, it goes to an administrative complaint. In this step it is very much like a courtroom with attorneys. If the FTC concludes a violation has occurred, they will issue a cease and desist order to stop the practice. The next step in the process is a hearing before the full commission. Appeals at that point would go to the U.S. Court of Appeals, then to the U.S. Supreme Court. The FTC was given power to use the legal and court system whenever it was deemed necessary. The 2 most common situations where the FTC uses a court is when a company violates a cease and desist order, or when the actions of a company are so severe that the FTC wants to stop the company from operating immediately. The FTC will also solicit the support and cooperation of state and federal attorney generals. The FTC has the power to require corrective advertising, which means the company must run a series of ads to correct the false and deceptive advertising and bring people back to the neutral state before the deceptive advertising. Since this is very difficult to do, corrective advertising is seldom ordered. But, if it is, companies are usually required to spend the same amount of money on the corrective advertising as they did on the deceptive advertising. The FTC will also issue trade regulation rulings, which apply to all firms within an industry. Normally, before issuing the rulings, the FTC will hold public hearings and hear both oral and written arguments. Recently, the FTC issued a trade regulation that bloggers who are compensated by a company must clearly state such on their blog or website. The FTC cannot handle all complaints, so the advertising industry has developed an industry system for overseeing advertising and marketing practices. The industry oversight process is voluntary. Companies do not have to abide by any decision that is made, but most companies will, because if it is turned over to the FTC or courts, the case is more difficult to win since the industry has already stated its opinion. The Council of Better Business Bureau will keep a record of complaints against companies. If a consumer requests information about a company, then the CBBB will issue a summary report about the company. It does not release the content of every complaint. To investigate complaints about advertising, The CBBB has three agencies: the NAD, the NARB, and the CRU. The National Advertising Division, NAD, receives complaints about advertising and marketing practices. The agency's role is to investigate the validity of the complaint and to collect information to determine if the complaint is valid and if claims made in the marketing practice or advertisement are substantiated. If after evaluating the evidence the NAD feels the ad or marketing practice is deceptive or claims have not been substantiated sufficiently, the agency requests the company to stop the ad or marketing practice. The NAD has no legal authority, but 95% of companies abide by the ruling. The NAD hears about 225-250 cases a year. In 50% to 60% of the cases, the NAD rules the ads are not sufficiently substantiated and must be discontinued. Only in about 5% of the cases does the NAD say the ad is okay. The National Advertising Review Board hears cases that are appealed from the NAD or cannot be resolved by the NAD. The NARB is made up of advertising professionals and civic leaders. If the NARB issues an order, it is very similar to the consent order of the FTC. The company agrees to stop the ad or marketing practice but does not admit guilt. The NARB ruling is not legal, just like the NAD. Any appeals or refusals to accept the decision of the NARB are referred to the FTC. In the last 25 years, only 4 cases have been referred to the FTC. The most common disputes heard by the NARB are complaints from one business about the marketing and advertising of a competitor. The Children's Advertising Review Unit, CARU, is a special agency of the Council of Better Business Bureau for handling issues in marketing and advertising that deal with children ages 12 and under. The CRU is especially involved in monitoring privacy practices on websites that children visit. The CRU operates in a similar way as the NAD. But, in addition to hearing cases involving advertising and marketing to children, the CRU will pre-screen ads directed to children. The company examines about 300 ads per year and provides advice to companies on the appropriateness of the ads. The CRU operates under the basis that children 12 and under do not have the reasoning powers of adults, and as a result advertisers need to act responsibly. What adults would quickly see as puffery and not real, children may not. The CRU has issued some guidelines for advertising to children. These guidelines are based on the concept that children cannot reason as well as adults, so advertisers need to be careful about what they say. It is easy to blur fantasy and reality in an ad, but a child normally cannot see the distinction. Industry regulations and oversight offer a number of advantages over using the FTC and legal channels. The cost is much lower. Resolution is faster. Cases are heard by attorneys and business professionals with experience in the advertising industry, not judges. IMC and ethics. Advertising or marketing practices may be deemed legal, but are they ethical? Morals are beliefs or principles that individuals hold about what is right and wrong. Ethics are moral principles that serve as guidelines for individuals and organizations. Marketing and advertising practices are affected by ethical and moral concerns. Some critics say advertising causes people to purchase more than they can afford and as a result end up deep in debt. They also argue that advertising puts too much emphasis on material goods and that it creates a feeling that material possessions can bring happiness. Marketers' response is yes, marketing does stress buying goods and service. That is what it is all about. But, consumers still have the freedom of choice. No one is being forced into making a purchase. A related argument against marketing is that it increases the costs of products. Yes, it does. Marketers will admit to that fact. But, through advertising, people become aware of goods and services and what they can provide. Without advertising, consumers may not have access to this information. Advertising widens the base of potential customers and increases the probability of repeat purchases. These additional sales leads to economies of scales in production, which allows the price of the product to be lowered. So, in a way, marketing and advertising assist in lowering the price of products, not increasing the costs. Critics have argued that advertising perpetuates the stereotyping of men, women, and minorities. The question that has to be asked is, does segmenting a market based on gender, age, ethnicity, or other demographic variables create stereotyping. In this era of political correctness, it is a difficult issue. The prime reason for segmentation is to reach a smaller demographic audience that possesses similar traits, interests, opinions, and lifestyles. Is this practice unethical, is it bad business, or is it reality? Another criticism of advertising is that it promotes the use of potentially harmful products, such as alcohol and tobacco. Experts estimate by the time individuals are 18 years of age, they have seen 100,000 beer commercials. Many of these ads use sexuality and social acceptance to make tobacco and alcohol attractive products. This was one reason legislation was passed to ban tobacco advertising. But, to bypass this regulation, tobacco companies turn to sponsorships, where the tobacco company's name is mentioned frequently. Many do not like the advertising of feminine hygiene products, sexually related products, and other personal products. In the international arena, advertising of these products is often prohibited or carefully regulated. Some of these ads use nudity and sexual themes. Some are embarrassing, others promote sex. Marketers argue that companies have a right to advertise just like anyone else, based on freedom of speech. Advertising to children is one of the hottest topics when it comes to ethics. Children represent a huge market in terms of personal buying power, but also in the family purchases they influence. Critics not only find fault with advertising to children, but the tactics being used, since children do not have the ability to reason like adults. Brand infringement involves using a brand name that is already being used or a brand name that is very close to another brand name with the intent of capturing sales from its popularity. Another problem comes when a brand name becomes generic, such as Xerox and Band-Aids. With the internet, has come domain squatting, which involves purchasing URLs related to companies or famous people with the intent of selling them to the person or company for a huge price. Another issue revolves around the marketing of professional services. In the past, it was considered taboo and unethical. Now both medical and legal professionals advertise on a regular basis. The rationale for advertising is freedom of speech, and competition has forced them to advertise to compete effectively. Others argue it is unethical because they are taking advantage of people's problems. Advertising by pharmaceutical companies has raised debates about whether it has increased the use of drugs, legal, in America and driven doctors to prescribe medicines when it was not really in the best interest of the patient. Gifts and bribes are used in business-to-business sales to influence purchasing decisions. At trade shows, companies will often entertain clients and prospects. In some countries, bribes are legal and allowed to be deducted as a tax expense. In others, it is the accepted way of doing business. But, in the US it is illegal. Some companies have policies that prevent their purchasing agents from accepting any type of gifts, even an ink pen. Technology allows companies to collect information from people. Many view this as an invasion of privacy since people have not granted permission. But, marketers argue the information is just being used to improve marketing reach and to facilitate the personalization of websites, which 95% of consumers want. Spam and cookies present some legal issues and certainly some ethical issues that are still being debated. The rise in sponsorship costs and expenditures has created a new problem, ambush marketing, which is a brand's association with an event when the brand has not paid the rights to be an official sponsor. Official sponsorships can cost millions, such as with the Olympics. So companies look for ways to capitalize on the event without paying the high costs of a sponsorship. It certainly is an ethical issue, but some would say it is just wise marketing. Direct ambush marketing occurs when firms intentionally design ads or marketing campaigns to capitalize on a major sporting event to appear to be official sponsors when they are not. Indirect ambush marketing occurs when a firm suggests or hints it is associated with a sporting event when it is not. Illusion ambushing creates an impression that the company is a sponsor, when it is not. Distractive ambushing is when a company designs a promotion or event near the official sporting event to garner attention of fans attending the event. Saturation ambushing occurs when a firm increases its advertising and marketing exposure during a major event by purchasing spot time or using other means of acquiring additional advertising time or space. Incidental ambush marketing occurs when a brand is associated with an official event without any intentional or indirect effort on their part. It just happened. A recent and controversial marketing approach is stealth marketing, which is an attempt to get consumers to look at a product through a personal contact without them ever realizing it was a sales pitch. The person making the sales or product pitch never identifies himself, herself as a sponsor of the brand or the motivation for demonstrating or discussing the product. Some argue this is just a shrewd marketing approach that is designed to get around clutter and is perfectly ethical. Others argue it is unethical and deceptive, since the sponsor or brand ambassador never identifies his or her personal ties with the company. Hedonism is the philosophy of life that maximizes pleasure and minimizes pain. Homeostasis is the natural craving for a balance in life. Laws are passed to provide a guideline as to what society says is right and wrong behaviors. Religion also offers guidance in terms of ethical behaviors. Religion offers a philosophy of living. Many religions teach the concept of the golden rule, treat others as you would want to be treated. Then there is common sense, which relies on logic and reasoning. Some call this a person's gut instinct about what is right and wrong. The difficulty is that there are many situations that are gray, not clearly right or wrong. In response to what has occurred with unethical conduct within businesses, companies have developed ethics training programs, codes of ethics, and ethics consulting systems. Codes of ethics have been developed by most professional organizations. For marketing, it is the American Marketing Association. Most companies have developed codes of ethics to govern workplace activities. Ethical hotlines have been developed where people can report unethical conduct. Laws have also been passed to protect the whistleblower from retaliation.